Okay, Assalamualaikum warahmatullahi wabarakatuh. We will explain the pros and cons of judicial settlement in international dispute. Next slide. For introduction, there are various ways in which international disputes are resolved. Within the international order, there are both binding and non-binding procedures for the peaceful resolution of disputes and conflicts. Conflict resolution techniques are divided into two categories, which are diplomatic procedures and adjudication. Peaceful resolution of international dispute is a fundamental principle of international law that was developed in the United Nations Charter under Article 2, Paragraph 3 of the Principle of International Law relating to cooperation and friendly relations among nations. It has always been the goal of international law to develop methods and means for resolving conflicts among states through peaceful and just means. In this regard, international law rules take the form of lawmaking treaties and customs. In the case of an international dispute, the dispute must be between nations. However, it does not become an international dispute until it taken up by the government of the injured nations. Following that, the aggrieved nation must take some action. This paper will discuss the pros and cons of judicial settlement in international disputes. Next presenter, please.
So the first process is consensual process that is utilized whenever the party at issue attempt to achieve a mutual agreement without incorporating any kind of legal entity in the process. So this process, which include negotiation and mediation, which are typically referred to as alternative dispute resolution approaches. So there are two primary categories of consensual process, which can be differentiated from one another based on the participant. First, there is a process known as self-resolution or negotiation, in which only the party themselves are involved. Second, there is possibility of a third party mediator helping the party work out their differences without having any decision-making power. Therefore, the best example of this type of process is mediation. However, consensus building approaches is to resolve conflict are highly effective in many contexts. Next presenter.
So next is the negotiation pros and cons. Next slide. In the modern world, tensions and confrontations can arise between any state at any time. A new strategy for resolving disputes is required in order to preserve stability and promote peaceful interactions and circumstances between the within states. It is in the interest of both states and their citizens to resolve problems and lessen the potential of future disputes and war. A variety of delicate methods are needed for dispute resolution. While governments most frequently settle their dispute through negotiation, other means and procedures such as the function played by international or regional organizations. Next slide. So the pros of the negotiation. First, negotiation is probably the most flexible form of dispute resolution as it involves only those parties with an interest in the matter and their representatives, if any. Second is, like any method of dispute resolution, negotiation cannot guarantee that a party will be successful. Next is negotiation is a voluntary process. No one is required to participate in negotiations should they not wish to do so. Next slide. The cons of negotiation. First is a particular negotiation may have a successful outcome. However, parties may be of unequal power, and the weaker parties may be placed at a disadvantage. Next, a successful negotiation requires each party to have a clear understanding of its negotiating mandate. And last, the absence of a neutral third party can result in parties being unable to reach agreement as they may become incapable of defining the issues at stake, let alone making any progress towards a solution. So I pass to the next presenter.
Next is mediation, pros and cons. Next slide. So mediation is a process that involves the neutral third party as the mediator. to encourage attempts by the opposing parties to reach a settlement and a mutual agreement towards ending a conflict. A neutral third party's role in mediation is to assist parties in reaching a mutually agreeable solution on their own. Skilled mediator works together with the disputing parties to uncover the interests that motivate their viewpoints rather than enforcing a solution. Parties are able to express their emotions and fully explore their grievances during mediation. The responsibility of the mediator is to help the parties to negotiate a settlement. The mediator only supports the parties' dialogue and negotiation during a facilitative mediation. Next slide. For the pros of mediation, informal and flexible. It is informal and flexible as no legal counsel is required. Next, there is no need for witnesses and evidence to be presented. Third, highly confidential, where any information disclosed during the mediation shall not be disclosed by the mediators. Next, a quick process where it takes lesser time to be completed, enabling a quicker resolution than it is feasible with investigation. It produces customized and comprehensive agreements and can customize their agreement to fit their unique circumstances and take care of the implementation points. Number seven, promotes preservation of relationships and promotes mutually satisfying outcomes. Next slide. The cons of mediation, number one is the results cannot be guaranteed. So, as mediation is a negotiating process, parties may accept the suggested conditions and the mediation process as a whole may fail. Third, parties would be forced to spend money and time in this situation without getting anything in return. Next, mediation process is usually connected to withholding information that could lead a party to fail to be completely open and honest. Number five, the absence of any written norms. Number six, the setback of informality is that it can be very challenging to anticipate how a mediation will proceed. And the last one, if the mediator lacks expertise or inexperience, he or she may make the process more time consuming and the mediation become ineffective. Next presenter.
So the second process or settlement dispute is an adjudicative process. What is an adjudicative process? It is an adjudication is the process of settling a legal matter or claim through the court or justice system, as well as a legal judgment or judgment that is typically final. Adjudication can more broadly apply to any formal processes of judgment or judgment that provide a final result. Adjudication refers to a legal procedure that enables a court to quickly and effectively resolve a dispute between two parties. The process is governed by formal standards of evidence and procedure, and the initiating party or trier provides a notice defining the facts in question and outlining any applicable legislation. And there are two types of adjudicative process which are uh, arbitration and trial. So I'll pass to the next presenter.
Alright, next is arbitration. So arbitration is the non-judicial resolution of a conflict between contracting parties. According to Article 287 of the Convention, one of the four methods for resolving dispute over the interpretation or implementation of a maritime boundaries in arbitration. The parties who initiate the arbitration action must designate one arbitrator from the list, ideally one who is a member of that party's own nationality. The arbitrator tribunal rulings are determined by a majority vote of its member. Next slide. The pros of the arbitration is, comparatively speaking, arbitration is more adaptable than ICJ or the judicial process. The party have greater flexibility and choice in arbitration, particularly if a matter is filed before the arbitrator court on the basis of the unique agreement. This, this confidentiality is helpful in cases of maritime boundaries dispute. The disputing parties retain control over all aspects of the arbitration process, from the nomination of the arbitrator to the choice of the rule and procedure. Next slide. For the cons of the arbitration is one of the drawback of the arbitration is the additional cost associated with the nomination of the arbitrators in accordance with Annex of the agreement. In contrast of the ICJ, where all costs are covered by UN 16, arbitration tribunal have considerable costs, including expensive fees paid to the arbitrator and court registers, as well as the rental charge of the space where hearings are held, secretarial and translating service. Another potential drawback of the arbitration is the nomination of arbitrator taking longer than expected, and the president of it lost make appointment with the ulterior motive if the president is of the nationality of one of the parties in dispute. That's all from me. I pass to the next presenter.
So next is for the pros of trial. One of the most significant advantages of a trial is that the procedures are far less casual. It's a formal process, so a judge is less likely to rigidly enforce and impose on courtroom procedural standards, and is much more likely to ignore many of the evidentiary rules that become so contentious in jury trials. Furthermore, in a judge trial, defendants and their counsel are not required to deliver opening comments, so there is also no necessity for the judge to have judge decision written. While there is a very rigid method for constructing agreements in a jury trial, this formality is sometimes ignored in a judge trial. So a judge is considerably more inclined to accept evidence that would be refused if a jury was present. The defense and prosecution counsel also are more likely to receive the opportunity to debate and even agree on some essential facts of the case. So such adaptability might offer several advantages. So judge trials are frequently far less time consuming than jury trials due to the formalities that must be fulfilled and the fact that a jury must be picked. So these are items to think about when weighing your alternatives. It is also critical to analyze your specific case in charge when deciding between a judge trial and a jury trial. So next slide please. So there are disadvantages as well. One of them is the unknown outcome. So even when the issue appears to be obvious on the petitioner side, there is sometimes some doubt regarding the case outcome. So you may not know how the defendant will approach the case, what material will be presented that you may have overlooked, or how the judge will perceive the information gathered. So aside from that, it is in the event of a case dismissal. Sometimes halfway through the case, the court chooses to dismiss it due to a lack of grounds and evidence, resulting in a loss of resources such as time and money. So this also creates an unbridgeable gap between the persons concerned. Furthermore, because trials are public, you will have a more difficult time safeguarding your confidentiality during the procedure. So this might be emotionally draining for some people. Lastly, it is longer waiting period, which is in a settlement. Damaged parties should be compensated within 30 days after reaching an agreement. Trials, on the other hand, might go on for a long period before reaching a decision, whether to settle your personal injury lawsuit or take it to court is a critical choice. So the decision is to proceed trial, not is based on the facts of the case. So finally, an expert personal injury lawyer will understand how to proceed and which alternative will allow you to optimize your rehabilitation. That's all from me.
Okay, in conclusion, tensions and disputes can occur anywhere at any time and between any governments in the modern world. Maintaining stability and maintaining peaceful interactions and circumstances between and within nations necessitates the development of a new strategy to conflict resolution. Addressing conflicts and reducing the likelihood of new disputes and conflicts in the near future is in both nations and their people's best interest. Judicial settlements have the advantage and disadvantages in solving any conflict between states. That's all from us. Thank you.